I am a divorce mediator, and I'm constantly amazed at how many parents who interview me think they can do without the other parent when divorce is imminent. They usually pursue the money. Ladies and gentlemen, there's a fallacy in our divorce culture. If this is you, you're just not up to speed on parentless child development. Child dysfunction is increasing at an alarming rate, and because of sole custody court decisions doesn't help. Divorce does not mean you divorce your kids from the other parent. For 20 years, I've seen the child dysfunction grow insidiously while the alienating parent remains in denial, wondering why that happened to them. The empirical studies confirm sharing the parenting post-divorce is the best choice. Post-divorce is the best choice. Okay, today I have with me Jeff Bloom, who's a divorce mediator, and we're going to talk about a lot of the misconceptions about mediation because there are plenty. Okay, Jeff, what are some of the misconceptions about
There are many, Chris. Even though mediation has been around for 40 plus years, there are people who don't know about mediation exists, and that's one of the hurdles initially. The other one is, people come to me all the time, and I'm sure you also. Where were you 5 years ago? I didn't know mediation existed.
Right.
I ran out of money. If I killed my wife, I'd be out of jail by now. I mean, you hear it all.
Yeah.
And it's a viable way to get a divorce where the parties are in charge of the process, and they can have an agreement at the end they could both live with not only now but in the shadow of the future.
Yeah, one of the primary things I think about mediation that I'd like to share with the audience is that it's a peaceful negotiation, which a lot of people who are under strife or having difficulty managing the conflict that they're having in their own lives can't relate to the fact that they are going to now sit in front of a mediator and communicate effectively.
Well, absolutely, and that's
a block.
Concern. And you have attorneys who will swear and tell people that you can't go to mediation, you got to go to litigation, and you have to, you have no control over the process in the litigation versus the mediation process.
Right.
What the audience is looking at now is a chart that I kind of threw together. And if you look on the left side of the chart, you have the judge on top, you have the two attorneys, the A's, and the parties. Now, if you're going through the litigation process, each party is going to hire an attorney. They're going to pay a $15,000, $20,000 retainer to start, and that's not going to be all-inclusive. And each party has to talk to their attorney to tell them what they want. Their attorney is going to talk to each other attorneys. And if you ever get to court, after deposition and everything, only the attorney is going to talk to the judge, and the judge is going to make a decision based on the law, period, not taking into consideration what the best interests of the children are, what's best for the couple. So there's no control. You don't know what a judge is going to do.
In that scenario, the couple's not talking.
No, not at
to
all.
each other, okay.
Every once in a while, a judge might ask a question, but generally, no.
Yeah.
And the judge is going to make a decision. This is hearsay. You can't say this. You can't say that. Mediation, if you look on the right side of the chart, you have the mediator and you have the two parties, and there's communication between all three parties all the time. So you have the husband and wife, or the wife and wife, whatever, in a room together, or the husband and husband, whatever the situation is, and they can talk back and forth to each other and relate to the other one why these issues are important to them and what the underlying issues are. And even though they might think what they know what their spouse wants or what they don't want, and think they know what they're going to say, while they might not admit it, when they hear it in a room, they might take a step back and say, wow, I didn't know that was important to him or her. And these are the issues that need to be resolved. And why not go back and forth between the two parties in the room there? And you can't do it in court. In court, there's the rules of evidence and what's hearsay, and that doesn't matter. But it does matter, right?
Yeah.
All these issues matter to parties. Everything's on the table in mediation.
It's very funny that you think that when you first loved your significant other, that you shared in communication, you talked to one another, and you built a relationship where levels of conversation can be had and problems can be meted out in discussion. And even if there were issues, by the way, no communication is perfect. So there's always going to be an issue at some point.
Of course.
There's no such thing as people being exactly equal. But what always strikes me is that at the point of divorce, when divorce is imminent, the cloud that covers everybody is the litigation cloud. Because somebody in the family had gotten an attorney that they liked, or they were benefited by this attorney in some way. In reality, most people are not benefited by that process. Most people are not real. They think that they got a good deal if they lost $40,000 or $50,000, and somehow they, that's a good deal.
$50,000 to get $10,000 in one of in a pension plan or something like that.
It's how
it doesn't
awkward.
make sense.
No, it's how awkward that is, and when you think about it.
So do you want to spend $50,000 each for litigation, or spend less than $10,000 total for mediation and get what you want.
The other myth attached to all this is that there's a myth that justice is going to prevail, that there is no guarantee that justice is going to prevail for you.
No, there's not, and as we just talked about a little earlier, you don't know what a judge is going to decide. Judges, you go before the judge, and he maybe reads your case maybe a half hour, 15 minutes before it starts, because they're inundated and they have a lot of cases, 300 cases,
Yeah.
whatever the case may be, and he can look at it and he can say, you do this, and that's going to be it. Somebody's going to win, somebody's going to lose. Generally, the loser will breach the judgment or any type of agreement that's reached in court, and you got to bring them back to court and spend more money through the mediation process when they both have a say, and in the outcome, the mediator doesn't tell them what to do. Everything that's in the agreement is theirs. They're in charge of the process.
There should be something wrong fundamentally at the onset when your attorney says don't talk to your significant other. I mean, if you think about it, it's about a contest of winning.
It creates the adversarial environment.
Right? That's where it's all about. But there's something fundamentally wrong with not communicating with your significant other, especially if there's children involved.
Absolutely. Where the children are most important and the best interest, and so people use that term loosely, but that should be taken in consideration.
The judges can make mistakes, and there's no such thing as a perfect scenario. What I was also surprised about is the judge really doesn't do a heck of a lot, especially in the early stages of a court battle. The attorneys are manufacturing the process, right, and the clients are feeding off of the attorneys. It's kind of like the first scenario you talked about before.
They're creating the argument. They're creating the argument back and forth. Mm-hmm. You're my attorney, and I say I want the house and I want the car, and then you tell her attorney, and she says she wants the house and the car and she wants the boat.
Yeah.
And then isn't it easy for me and the spouse to communicate, but whether we agree or not, back and forth, rather than going through four different. You remember that game you used to play in school where the teacher would give a piece of paper to somebody in the front row, and they would read it, and they'd have to whisper to the person in the back.
Yeah, telephone.
And by the time we got to the other side of the room, it was completely different.
Yes, that's called telephone. Yeah.
So it's a similar thing like that. Why not be in the same room with the person you're arguing or negotiating with, versus going through 4 or 5 different parties to get your result?
Let's talk about some of these things that are also myths. Like, for instance, if you hire an attorney to fight and go to court, I will get what I want, and I'm entitled to things.
Well, you and I both know, right? Any attorney worth their salt can't guarantee anything, no matter how strong the case looks.
Because he has another side that's going to combat whatever it is that you want.
Not only that, but he doesn't know what a judge is going to do.
Right.
I mean, there's no guarantees or anything. You can give them an idea of what might happen, but there's no guarantees. You still pay the bill, too.
Yeah, that never goes away. What about an attorney mediator versus a non-attorney mediator?
That's a myth also. A lot of the old school attorneys, for lack of a better term, will tell you that in order to go to a mediator, make sure that mediator is an attorney. That's just simply not true. One of the main reasons are, if that attorney is wearing the mediator hat, he or she can't act as an attorney. She can't, and he can't give legal advice. He or she is not supposed to, during a mediation, tell you what you should or should not do.
Which is the reason why you hire a mediator attorney anyway. Sure, right. It's a little crazy.
As a mediator, you can advise them about the law, but not give legal advice, and there is a difference.
Yes, there is a difference, yeah.
I go to CLEs, I read case law, so I kind of know what the courts are deciding. So if they ask me, I will volunteer that information, but I don't blurt it out and give that information without them asking first, because again, they're in charge of the process. I want them to talk back and forth and come to an agreement while I'm there to just help clear the barriers. Mm-hmm.
What also is strange that this training for a lawyer, for an attorney, is totally different. As a matter of fact, it's just about fundamentally completely opposite that of a mediator.
Absolutely.
So our training being opposite, you would say, one of these people have to really not be the right selection for us.
And unless they go through a mediation training, just the sole fact that they're an attorney doesn't make them a mediator.
Well, the people that the classes that I have gone through over the years, and I've gone through many.
Me too.
I've always said that the people that were slowest on the uptake were the legal profession. They had the most difficult time not trying to figure out how I can decide and how I can make this couple go a certain way, when in reality you're not doing any of that. You're listening and facilitating. You're not commanding or arbitrating a couple when they're with you.
Right.
But these need to find what is legal in a matrimonial sector blows my mind, because when you think about it, what is really consistently always the same, other than a percentage on child support maybe? Or recently alimony changed, and then we recently had a no-fault change. Well, these are new laws.
Right, no fault, October 2010.
Right.
Which makes it easy for couples to get divorced. Now nobody has to take the blame or fault.
And New York was the last state to...
The last state to do it.
Right, to do it. Supposedly that was going to increase divorce. You know, it stayed about the same.
Did it stay? I thought it did increase a little bit, but I haven't read anything recently.
Maybe initially, but you know, over a short period of time you can see fluctuations, but over the last year and a half it's been about the same. I don't know why, but fundamentally that is it. Going through the mediation process means I have to give in and agree to some things I do not want.
Not necessarily. I mean, mediation is a negotiation. Both can't go in and say, I want the marital home, I want the marital home, or they have one child and they both want the son, you can't, cut the son in half. So there is some, for lack of a better term, give and take.
Well, wouldn't it be better to use the word cooperation? Because, sometimes you need to cooperate, and that sometimes means you have to detract from a stand.
Right. Instead of fighting over that, say, the issue with the child, what if they're in a room together and obviously you can't share exactly 50-50. There's 7 days in a week, so it doesn't work.
Right.
So I've mediated cases where, okay, during the school year, the mom will have, let's say, residential custody of the child because he needs to be more in a stable environment, going to school, and I get him 2 days a week, or 3, 4 and 3, whatever that case may be. And in the summer we switch. Mm-hmm. And then and then maybe the dad gets the child for 2 weeks in the summer. They split vacations. I mean, that's more reasonable. And people, when you talk in a room together, they say, okay, that sounds reasonable. Then these are couples who understand what the best interests of the children are, and that's their focus.
It's funny, when people look at, you have to agree to mediate. A lot of people say that. That's a myth also, because you don't have to agree to mediate. You can be in total disagreement and still mediate.
You have to agree to at least start the process.
Well, that's another story. I'm talking about the conflict issues.
Correct. Well, one of the benefits is mediation is non-binding and you can stop at any time.
Right.
So why not give mediation a shot?
If you so choose, exactly. Right. It's going to keep the cost down.
Right, just so you know what your options are.
And the people who aren't willing to cooperate in a mediation session often have something to hide, because they don't want to divulge all the communications necessary. They want to battle that out. They want to win something.
Well, they also think, and one of the other myths that you just brought to my attention, I remembered, is they think, well, if we can't agree on stuff now, and we're always fighting, how are we going to agree to mediation? Right. But it really is completely different. When you sit in a room at a table across from each other or next to each other and talk about what's important to you, I mean, at some point you dated, you met somebody, you dated, you got married, you fell in love, you had children, so there was communication at some point.
Yeah.
So it's not going to be a total thing. Maybe in an extreme case of domestic violence or abuse, something like that, mediation may not work. But other than that, it works. I've seen it. I've done high conflict couples.
Yeah, I have too. That's what I'm surprised about, is that this notion that you can't have a successful mediation because there's the conflict is going to be an issue.
There could be 10 items. They could agree on 8, and mediation could be about 2.
If a mediator and attorney, they can tell me what I'm entitled to, so I won't get screwed or taken advantage of in the mediation process.
Well, again, that's giving legal advice, right? How could you, if you're a mediator and you're telling a party what they're entitled to, then you're giving legal advice, and now you're not a mediator anymore. Now you're not a neutral third party. If I'm in a room mediating, and you and your wife are here, and I tell you, forget about what she just said, Chris, and you're entitled to this. I'm not a mediator anymore. I'm not neutral.
That's right. You're giving
now
advice,
advocating for you. That's going to turn her off, or vice versa, and that kind of defeats the process.
I like to talk about one word that mediators don't often talk about with other people, but they talk about it amongst themselves. Mediation is magic. What do I mean by that? It's magic. I mean,
people realize how easy it is and how the process goes after it all said and done.
Yes.
I had a high conflict couple last year. She had an order of protection against him, wasn't due to physical anything, and it was very high conflict. And at the end, and I never thought we would get to an agreement just the way it was going. And at the end, she thanked me as well. You're very calm. You helped us, come to a decision on everything. So it can be done. I've
had mediations where the couple will stand up and get out of the room, or they'll go to another room, and you don't know when they're going to come back.
I've had that.
And
I quit.
So those things do happen. Those are high conflict. They're yelling and screaming at one another. But as a mediator, you don't have to necessarily think there's an outcome on someone being upset about the conditions that they're dealing with and cooperating in a mediation process.
And it may be an example to take a break, or maybe cut the session short and continue the following week.
Take the heat off the collar, stuff like that. Sure.
Yeah. Or meet each of them separately. Sometimes when you do like a caucus type session where you each meet with each separately and give them the same amount of time along with the mediator, then you can really get to some of the underlying issues and see what's really...
Right. Often it takes a second and the third session to get well underway.
Absolutely.
Yeah, sometimes that first session is difficult. Mediated settlements don't stick. Do you get a better deal using a mediator attorney? We skipped the second part about using the mediator attorney, but mediated settlements don't stick.
Sure they do.
Where did that notion come from? I know it's a myth.
I've never heard that. The only thing I've heard, they say, well, mediators who aren't attorneys can't draft agreements. They can. I went through the training and to draft an agreement, and I've also graduated law school. But besides that, I have a review attorney that reviews it on my behalf before I present it to couples.
Right, and that's what you're supposed to do.
Right,
That's
and
what
the
you're
couples
supposed
can take it to their attorneys for review, which they do most of the time. So you don't need a mediator attorney. You just don't. And why spend $4,000, $5,000 for an agreement when you can spend $1,500 to $2,000?
That's the other myth, is the cost factor. Some people think that mediation is similar in cost to litigation.
No, I would say the average mediation, and you could probably concur with this, is even on the higher end, it's less than $6,000, right around there.
Right.
That's if you have to have some experts or forensic accountant.
And it could be as little as $2,000 or $3,000.
Could be as little as $2,000 or $3,000, which is more of the average. Again, you go to litigation, $15,000 retainer each minimum, 10 to 15.
Retainer minimum on an average, $15,000. Yeah.
And that's 30 grand.
Yeah,
and then,
that's right.
And that's not going to be all you're going to pay.
Sure.
Right?
Every motion is another $2,000, whatever it might be.
Phone calls and billing and talking to the other attorney and going back and forth.
Meanwhile, mediators don't charge for phone calls. What else don't we do? We don't charge for visits. Actually, you're paying for your session. That's it.
Right. Yeah. I don't charge for phone calls. I don't anything extra. I do.
No emails or anything else.
Emails, nothing like that. No.
Yeah, it's amazing, right?
Yeah.
Some people say, and this could be a problem we have, not necessarily a myth, but my ex couldn't find his way out of a paper bag, never mind having a decent access schedule to the children. The complaint feature being that which is brought to the table is that I wouldn't go to mediation, for instance, because how am I going to get this person to agree? They can't even do anything, whatever it is they might not be able to do.
Right,
so,
but doesn't that go back to the 10, 20, 15, whatever years of marriage? You have to agree on something somewhere. And maybe you started out as a disagreement, but now it's an agreement. So, are you willing to, again, spend 50 grand each, 30 grand each, to get a settlement on something that's worth less than $2,000 just to say you won? I mean, it doesn't make sense logically.
Yeah, it's absolutely crazy. Well, regarding anything else regarding this conflict situation you talked about before, the chart that's up there, the right side diagram, which shows the mediator and the two participants.
Right.
That's a communication circle.
Correct.
That's a triangle circle.
Everything's admissible. Whatever they want to say, they can say. There's no such thing as hearsay evidence or rules of evidence, and you can't say that. I mean, how many people go to their attorneys and I'm going to divorce my husband, and he did this, and he cheated on me, so I'm entitled to more money.
Yeah.
It's not relevant.
Yeah.
The parties can actually tell each other they're hurt in a mediation and tell them why. And again, it helps when you hear what the real underlying issues are.
Sure.
And what what it means to them. That's how you get to negotiated agreements.
One of the other problems people have in litigation that is not a problem in mediation, but people don't understand this, is that I have to sell my house, because a lot of litigated divorces force you to sell the house as an asset to distribute.
Right. Why do you have to do that?
Right. In mediation, we have all kinds of deals.
One could stay in the house and buy the other one out.
Right.
One could stay in the house
for a period of time. Right.
And they agree until kids go to college, and then when they sell the house, then they split the proceeds.
In exchange for a dollar's amount of value coming back to them in the form of either alimony or child support.
Correct.
You can have access to the house.
Everything's flexible.
Free rent. You can make. That's why another reason why it's magic, by the way.
Because it's flexibility.
There's huge flexibility in mediation. Creating an agreement in mediation is actually fun, because you don't know how the couple is going to come up with these, and they come up with some wild stuff sometimes.
They do. And what you may not think is fair as a mediator doesn't matter. If they think it's fair and it's something they can live with, then it's their agreement.
Jeff, I want to thank you very much. Believe it or not, this is the fastest show on earth. Thank you very much, Jeff Bloom. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. We always invite all opposing views. My name is Chris DiMaggio, and thank you very much for watching FIT TV, and we'll see you again next week.
properly inflating my tires burns less fuel and saves me money on gas. Yeah, I'm saving Mother Nature from pollution, but more importantly, she saved me $11. Ow!
Environmental defense. Get green.
By keeping my car regularly tuned, I save money on gas and repairs. That also means cleaner air. You know, feels good to help save the cash, planet.
Environmental defense. Get green. For more tips, go to getgreen.com.
Introducing the all-new Enclave. It's a minivan to the max, with features like remote control sliding rear doors, 150 cable channels, a full sky view roof, temperature-controlled cup holders, and the 6-point navigation system. It's the minivan for families on the go.